May it please the court, my name is Dave Mkrtchian, and I will be representing the respondent, Javier Alvarez. I'd like to begin by reframing the question at hand, reframing the statements of my client. The false claim that my client made of winning the Medal of Honor is neither defamatory nor fraudulent. It does not fit into any of the narrowly limited classes of unprotected speech. I'd like to begin by describing why it's not defamatory and why it's not fraudulent. First of all, if the speech was defamatory, where is the individual that is being harmed, and what is the harm that is being done? I would like to argue, as Chief Justice Shapiro did, that the very fact that one would claim the honor of winning the Medal of Honor is reinforcing of its prestige. Moreover, it's not fraudulent because this honor was not claimed before coming into public office. It was claimed the day he got into public office. He had neither voters to court nor money to receive in funds. And so the Stolen Valor Act is creating this class of unprotected speech that historically has been protected. And so
excuse me, counsel, I mean, someone who is in office and has been elected may have an interest in still being popular, right? They may wish to seek other offices, they may wish to be reelected. Isn't that a factor here?
It would be a factor, Your Honor, but even if we concede that this person has an interest in winning office in the future, it's unclear to me what damages are being done by this false claim in seeking that potential future office. I'd like to begin with a slightly different approach to the precedent regarding false factual speech. I would like to go back to precedent set nearly 100 years ago in Schenck v. United States. Although the standard in Schenck v. United States, as of right now, is no longer particularly applicable, I'd like to remind the court, of its history. Oliver Wendell Holmes held that the most stringent protection of speech would not protect a man in falsely shouting fire in a theater and causing a panic. The question in every case is whether the words are used in such circumstances are of such a nature as to create a clear and present danger. These words were used by Justice Holmes in protecting the Espionage Act of 1919. They were later used in Brandenburg v. Ohio. And in Brandenburg v. Ohio, the standard established described the lawless incitement of certain inflammatory statements. And what I would argue is that Javier Alvarez's statements, neither being defamatory, nor being libelous, nor being fraudulent, are inflammatory. But even if we assume that these statements are inflammatory, they do not present a clear and present danger. Imminent lawlessness were the words that were used by the court.
Is the clear and present danger test the current test the court is employing?
Yes. Yes, Your Honor. I'd like to go on to question the compelling interest that the government is serving in criminally holding.
Counsel, before you move on to that, what about the language in Gertz that indicates that false statements of fact aren't actually protected by the First Amendment?
The language in Gertz is ambiguous because the language in Gertz did not hold per se that false statements of fact are constitutionally protected. If I may quote the court, the erroneous statement of fact is unworthy of constitutional protection. If the court wanted to hold that knowingly false factual statements of fact are unworthy of constitutional protection, then the court's opinion would have been instead of like Justice Powell's majority opinion, would have been more similar to White's dissent. And in Justice White's dissent, we see language that is more similar to what you're describing. I'd like to go on to discuss the protections given to Javier Alvarez's speech, assuming that it is neither defamatory nor fraudulent. If we assume that it's inflammatory speech, then, as I said earlier, the standard that would apply is clear and present danger. If we assume that perhaps the speech in question is defamatory for the sake of argument, I would point the court to the precedent set in Garrison v. Louisiana. The court held that a true statement even if made with malice, could attract sanction, holding that only false and malicious statements could be liable. And this Garrison v. Louisiana only permitted defamation actions in which there is, quote, an intent to inflict harm through falsehood. It is unclear to me whether the statements of Javier Alvarez fit this intent to inflict harm through falsehood.
Counsel, in Garrison and also in New York Times versus Sullivan, what the court's concerned with there is that if they hold the speaker or the publisher or the writer to a high standard for showing that their statements are truthful, that it will chill other kinds of expression that are true. In this case, I don't see where the chill comes in. It seems to me like your client knows his statements are false. They're about himself. They're not about someone else. And that seems to me a key distinction in this case.
Your Honor, I can see the objections you're making. I'd like to discuss with respect to the chilling effect of these speeches, how that comes about. I'd like to, by the way, point the court to the actual language of the Stolen Valor Act, because we submit that the opinion imposed on the language by co-counsel is does not reflect the language. There is no exemption in the Stolen Valor Act for political speech, for artistic speech. These exemptions, if I may continue, these exemptions would apply in a case of, for example, a Vietnam War protester claiming that they had won the Purple Heart. It is unclear whether the Stolen Valor Act, as it is written, would apply to that case. It is neither narrowly tailored enough, nor is it pursuing the least restrictive means. As on a federal level, with the much maligned exception of the Alien and Sedition Act of 1798, we have thus far, with the narrow exception of speech that is inflammatory and may incite lawlessness, with that narrow exception, we have never held knowingly false statements of fact, individuals who have stated knowingly false statements of fact to be criminally liable.
So, counsel, is your argument that as applied to your client, this actually is constitutional, but facially the statute's unconstitutional?
No. My argument is that even if we assume that the text of the Stolen Valor Act, or even if we assume that the Stolen Valor Act is not trying to, even if we assume that the Stolen Valor Act's language is specific enough, even in my client's case, one could see shortcomings in applying this. If I may continue.
Let me stop you for a minute. There are perjury statutes. There are fraud statutes. There are penalties attached to making various false statements in applications for government assistance of various sorts, and in making false statements in applications for citizenship. So indeed, there are many statutes that attach penalties to making false statements. I don't understand your argument that there are no such statutes.
There are such statutes, but if I may give the court a little bit of history, from 1992 to 2004, there were 18 criminal statutes regarding defamatory or libelous actions, and there were only 6 convictions. And in the entirety of that time, there was no federal statute, and that is because I believe of the holding in Garrison, Louisiana. The New York Times rule, according to Garrison v. Louisiana, the New York Times rule also limits state power to impose criminal sanctions for criticism of the official conduct of public officials. And if we are to assume, as counsel would like us to do, that the individuals being harmed here are Medal of Honor recipients, then the very fact that the Medal of Honor is such a high honor, it would be public for people. And in this respect, Garrison, Louisiana, set out an amorphous, albeit still, an amorphous standard, but still standard that stands precedent. I'd like to go on to more recent cases regarding false statements of fact, and point to numerous protections, even in the most compelling case, Gertz v. Robert Welch. it is important to remember the context of Gertz v. Robert Welch, and that the individual in question was a private individual. Even though there isn't even an individual mentioned, there are no individuals who are receiving this individualized harm, presumably from the diluted value of the Medal of Honor. The court held that that defamatory statements are unprotected if they are made with the culpable state of mind and cause injury to another person. Even in that circumstance, that was applying a lower standard to private individuals, which the individuals who would be receiving the Medal of Honor plainly are not. Finally, I'd like to get into a very recent case this court has decided upon, United States v. Stevens, precisely to discuss the balancing that the petitioner would like us to do. The United States v. Stevens conclusively established that a free-floating test for First Amendment coverage is, quote, startling and dangerous. The First Amendment's guarantee of free speech does not extend only to categories of speech that survive an ad hoc balancing of relative social costs and benefits. And in an understanding that the court does not make an ad hoc judgment, case by case, such that one case may be determined to be at one point in time unprotected speech and another protected speech. In the spirit,
do you take this decision as overruling Barenblatt?
I'm sorry, Your Honor, I'm not familiar with that precedent.
Don't proceed.
And in conclusion, I would like this court to hold the Stolen Valor Act of 2005 as written unconstitutional. Thank you for your time.
Let me hold you for one more second outside his time. Let us suppose I wish to create a new exception doctrine, like the obscenity and libel doctrines accepted from First Amendment protection. I view your client's speech as utterly without redeeming social importance, which is the court's rationale for excluding obscenity from First Amendment protection. Do you have any response to my proposition that his speech was utterly without redeeming social importance?
Speech with utterly without redeeming social importance was discussed in Hustler Magazine v. Falwell. And in that case, the court noted that prescribing a rule that would not overstretch the court's role in the United States would be very difficult. In fact, it held that although the speech in Hustler Magazine is not worthy of constitutional protection, it would be too difficult to prescribe a rule that wouldn't be too broad.
Thank you.
Thank you.